Brand protection for a trademark applicant or owner is limited to its classification or the class or classes the mark, which could be a name, logo, slogan, is registered in. A class is basically the category of goods and or services your mark is registered in. This is why it is important to have a general understanding of trademark classification so that your name or logo is registered in the accurate class or classes. Hi, I'm Sahil Malhotra, Principal Attorney at Drishti Law. Today I want you to learn a little bit more about the trademark classification system and how a calculated portfolio development can elevate your brand's visibility. Inadequate identification and description of the goods and or services provided under your mark can make your mark vulnerable to competing forces. For example, a non-downloadable software needs to be registered in class 42, but a downloadable software needs to be registered in class 9. Common errors like these in applications can delay or derail adequate protection if not filed properly. The USPTO provides a list of 45 classes for goods and services, 34 classes for goods, and 11 classes for services. Simply put, a mark is protected in the class of goods or services that you are registered in. Why you should care about trademark classes? Trademark classification is integral to the search and clearance, application, and registration process. For example, an already registered mark that is classified as a restaurant will not be in conflict with an applied for mark with a similar name or logo if it is classified as a financial advising service. For example, an already registered mark that is classified as a restaurant will not be in conflict with an applied for mark with a similar name or logo if it is classified as a financial advising service, as long as it is a financial advising service. The USPTO provides a trademark ID manual to identify the class that will apply to your good or service that is provided under your mark. You can find more information on how to use the trademark ID manual in a link I will provide below. If an applied for mark has similarities, example appearance, sound, connotation, with the name or logo of an already registered mark, the only way to overcome a USPTO refusal is to show that the applied for mark's goods and or services are not similar to the already registered marks. For new applications, the filing basis for each class is also integral to the application process and can result in variable costs depending on the route chosen. The difference between the filing basis is discussed further in another video I've done before. It also directly relates to estimating the USPTO fees involved during the application process. A TEAS plus USPTO application is $250 per class, which means an application for a coffee shop can be limited to just one class, but could also include other classes that include such things as merchandise like t-shirts, cups, house roast coffee, coffee drink names, etc. You might have a question if you could add more classes to your application at a later time. No. The USPTO does not allow to expand the classes of goods and services in a mark that is already applied for. Although they do allow you to narrow or clarify the goods and or services that you applied for, therefore to add any new goods and or services that are being offered under your mark, you would have to file new trademark applications. More information regarding adding additional classes can be found in the Trademark Manual of Examining Procedure. Another question you might have is, shouldn't I just apply in as many classes as possible from the beginning? Not necessarily. There aren't many small businesses or entrepreneurs who can afford thousands of dollars in USPTO fees alone. That approach only works for very few, and especially not for small businesses or startups. A more coherent approach is to protect what is current and to develop a plan to expand the brand's IP portfolio in a manner that aligns with the business's goals and ideals. As a business grows and expands, the originally filed trademark application might not cover the current goods and services that you are providing under your mark. For example, the coffee shop is now ready to sell their own coffee blends with unique names and logos. This new product offering must be protected by filing a trademark application to add or expand the goods offered under the original mark. There is an opportunity to protect the new product's name, logo, label, packaging in separate filings. Questions like, how many classes should you start with? When should you expand your brand's portfolio? Multi-class application filings, filing bases, and types of trademarks are all topics you should consider when developing a trademark portfolio for your business. Nobody better to help you with this than a trademark attorney. I hope I was able to clarify a little bit of the trademark application process, specifically the trademark classification system. As always, this is Sahil Malhotra. Thank you for stopping by.